report, as well as I visited with the attorneys. And for the record, we have also Ms. Randy King here, who is the assistant district attorney that handled the termination and CPS kind of portion of this case with regard to the children. I've received, has everyone had an opportunity to review the pre-sentence report?
Yes, Your Honor.
Are there any additions or corrections to that report?
No additions or corrections.
Ms. Smolfino?
Judge, I would just ask the court take judicial knowledge of the conversation we have had with the court and the understanding that this has been discussed at length upstairs. Ms. King has also provided me a tremendous amount of guidance, which I thank her and appreciate everything she's done with her wealth of knowledge and experience in guiding me through this case. I know the facts themselves are extremely egregious. It's difficult for all of us to look at. I would recommend Ms. Schultz is getting this opportunity because she has availed herself of certain things and tried to make progress. The children, her rights have been terminated, which she voluntarily gave them up, and they have been relocated out of state to a stable environment to where they will not have to testify against their mother, which was something that we took into a great deal of consideration. I would ask the court consider special needs safety in lieu of ISF cognitive. I think it is a more lengthy and a more appropriate term in custody as either an upfront type of sanction, but more so to give her the tools to be successful on this probation, because as the court is aware, and I'm sure Mr. Samuel has advised Ms. Schultz, and I do not mean this statement to seem punitive, but if Ms. Schultz is back before you on a violation of this probation because of this opportunity she's been given, the amount of time that the state will be asking for will be overwhelming.
All right, guys, today we're going to witness a courtroom moment where mercy is already on the table, but only because of painful sacrifices made before sentencing. The prosecutor explains that the children were moved to a safe environment and spared from testifying against their own mother. Yet this isn't forgiveness. It's a final chance wrapped in strict conditions. The warning is unmistakable. If this opportunity is wasted, the consequences waiting ahead will be far more severe than anyone in this courtroom wants to imagine.
Thank you, Ms. Smolfino. Anything, Mr. Samuel?
Yes, Your Honor. I understand the position of the state. However, I have to look at things from the position of the individual. The pre-sentence investigation report shows that she has no prior criminal history. It shows that she has no drug problem. There is a question about the alcohol. However, we believe that that can be done without the need of the inpatient treatment of the ISF. We believe that she's finally working. That is one of the most important things that she has to deal with in what she's gone through. She's experienced the trauma of relationships, and I think all of that is stated in the pre-sentence investigation report. But what you do not hear is the experience with the other partners of the children. She has carried this burden. She has tried to do the best that she could at the time. She's educated, she has a degree, but she has not been able to find employment. She's finally working, you know, and we just ask that this be held in advance for at least 90 days. That will show if there's an alcohol problem. That will show if there are other problems that she's experienced. She has been to a mental health specialist for counseling.
Buckle up, guys, because now the defense steps forward with a completely different perspective. Instead of denying what happened, the attorney focuses on the woman behind the charges, pointing to her clean criminal record, recent employment, counseling efforts, and years of personal trauma. It's a reminder that sentencing isn't only about punishment. It also weighs rehabilitation against accountability. The real question now is whether these arguments are enough to convince the judge that one final opportunity is truly deserved.
Well, Ms. Schultz, you're getting mercy today. You're getting mercy from these ladies as well as myself, if I go along with this agreement. Mr. Samuel has worked very hard and is very passionate about helping you, and I appreciate that. My position on this is based on a couple of things. One, the horrendous nature of this offense and what you put all of your children through, all 10 of them, is beyond anything that I have seen in 30 years of practicing law. 30. And so you're not walking out of here today. My initial thought was some upfront time, but if I'm going to stick you in jail, then I might as well put you somewhere where you're getting some help that you need, so that when you are released, you hopefully will be able to be a productive part of our society. But whatever trauma you've been through is incomparable to the trauma that you've put your children through. So at this time, I'm going to...
All right, guys, this is a moment where the courtroom falls silent, and every word from the judge carries enormous weight. He makes it clear that what these children endured is among the worst cases he has witnessed in decades on the bench. Even while granting mercy, he refuses to soften the reality of the damage done. His decision isn't driven by sympathy for the defendant, but by the determination to protect the children from reliving their trauma through a painful trial.
I will defer.
Notice something important here. The judge isn't calling this a win. He's making it clear that probation comes with strict conditions, intensive treatment, and constant supervision. In legal terms, this is mercy, but it's mercy with a very short leash.
When you're released, and you'll have aftercare through Spindletop, that is now part of your probation. So if you don't follow through with any mental health services that are recommended through Spindletop or probation, that's going to be a violation of your probation. You will also be ordered to remain in Jefferson County, Texas. You cannot leave Jefferson County without permission. You cannot go anywhere near or see your children. You've terminated that relationship. I know they're with family. And so there's no Christmases where you show up or they bring the children down or anything like that. That's done. That's over. If you want to leave Jefferson County, it has to be with my permission, and I will have to know where you're going and to what extent and things like that. If you do everything you're supposed to do on this probation, I cannot stress enough what kind of opportunity this is that you're being given. If you, however, violate any condition of probation, if you're back here in court, obviously this isn't a case that I will ever forget. And Ms. Malfino will...
Buckle up, guys, because the judge's final warning leaves absolutely no room for misunderstanding. Probation here isn't freedom. It's constant supervision, mandatory treatment, strict travel restrictions, and a permanent separation from the children. Then comes a statement that changes everything. One violation could erase the second chance and lead to years, or even the rest of her life behind bars. That's how seriously this courtroom views accountability after extending mercy. If you found this courtroom breakdown insightful, don't forget to like the video, subscribe to the channel, and turn on notifications so you never miss our next case analysis. Thanks for watching, and we'll see you in the next video.